of Justice and Legal Services. We have a quorum. The meeting is now called to order. Since the last meeting, we have issued CB4 849/1213, Regular 1 information paper provided by the administration on the biennial review of criminal legal aid fees, prosecution fees, and duty lawyers fees. Paper 2, CB4 895/1213, Regular 1. Letter dated the 9th of July 2013 from Mr. Dennis KWOK. It is in respect of the provision of duty lawyer service for claimant of torture, and this he asked to be included in the list of outstanding items. Another paper is CB4 911/1213/01, a letter by the Law Society of Hong Kong dated the 15th of July. It is a proposal in respect of 4B2, Legal Practitioners Ordinance, and also another provision. This is a view given to that amendment. And the other is CB24921/1213/01. Is also a letter given to us by Mr. Dennis KWOK on the 18th of July in respect of deciding whether a certain offense should be judged by is to be decided by a judge on his own or by a judge with juror. This is also a request to put the item on the list of outstanding items for discussion. And there is another letter given to us by Ms. Abraham Sheikh this morning, and that's CB4 925/1213/01. That should have been tabled, and this is a letter in response to the proposal by the Law Society, which is to have a uniformed, open, professional examination to replace the PCLL by the three universities. This is also an item that will be put on the list of outstanding items for discussion. As for paper CB4 911, which is the letter of Law Society, we are asked to comment on 4B2 of Legal Practitioners Ordinance and also amendment to that. The letter has been issued to members. If members have any comments, then you may give a notice in writing before the 30th of September. If you have any view, I don't know whether members have a chance to read the paper. In fact, there are proposals. I think it is worth being put on the list of outstanding items for our discussion. The proposal does have a number of implications. So if members are agreeable, so as to ask the DOJ to explain to us the policy of prohibiting overseas lawyers to practice in Hong Kong. If there is no objection, we can put it on the list of outstanding items. Let us now move on to the discussion item, and that is administration's paper on the Administration of Justice Miscellaneous Provision Bill. So that means all our proposals will be put on the list of outstanding items. Yes, indeed. Mr. Sheik's proposal is also put on the list. The one which was circulated will also be put on the agenda, on the list of outstanding items. I just want to put wait in line. Well, okay. Please refer to paper CB 4871-1213-01, the administration's paper on the Administration of Justice Miscellaneous Provision Bill. There is a legislative proposal, and therefore we have asked other members of the Council to participate in this discussion. If I may invite Mr. Lee to come to brief us. He will give you a PowerPoint presentation. May I welcome Mr. Esmond Lee. Mr. Lee, please.
或者我會用一個投影片嘅方式。
I will give a PowerPoint presentation on this paper, which is about the Administration of Justice Miscellaneous Provisions Bill. The bill has 6 parts altogether. The first part is appeals in civil matters to the Court of Final Appeal. According to the Hong Kong Court of Final Appeal Ordinance, an appeal lies to the CFA as of right, where the matter in dispute amounts to or is worth 1 million or more. This is the as of right issue. We have looked into this arrangement, and we have found several shortcomings. The system itself is not proper. We link the right of appeal to an arbitrary cash amount. The as of right appeal to the Court of Final Appeal will make the CFA to hear cases which are not meritorious. It leads to uncertainty and delay. And the meritorious side will not be given justice. And also unmeritorious appeal cases will make the meritorious cases, will delay the hearing of meritorious cases by the CFA. We have considered similar common law jurisdictions, and we found that nearly in all CFAs of the common law jurisdictions, leave has to be obtained. Our proposal is to change the law to the effect that, as far as civil cases are concerned, whether the amount of claim is $1 million or above or not, leave will have to be applied from the court before it will be heard by the CFA. This is in line with our criminal procedures. The second set of amendments is in relation to evidence taking by live television links. Under the Criminal Procedure Ordinance, there are specific procedures for vulnerable witnesses. Vulnerable witnesses can provide evidence and be examined by way of a live television link. The definition of live television link in the law is rather narrow. It restricts the technology to just a closed-circuit TV system. We propose to change the law to enable other suitable audiovisual facilities to be included in the definition of live television links. The third set of amendments is in relation to delivery of reasons for verdicts and sentences in criminal proceedings in the district court. According to district court ordinance, a district court judge is required to orally deliver the verdict and any sentence, as well as the reasons in criminal proceedings. The judge cannot flexibly switch to giving the reasons in writing. He must do it orally. And in many cases, this is unnecessary. It only wastes legal costs and court resources. We propose to change the law to dispense with the requirement for a district judge to orally deliver the reasons for the verdict and any sentence. The judge will be given the flexibility to hand down the reason in writing direct in appropriate cases. The fourth part is in relation to the calculation of qualifying experience for appointment as permanent magistrates. Under the present law, under the magistrate's ordinance, a person to be appointed as a permanent magistrate has to acquire no less than 5 years of professional experience, and that includes practice as a barrister, solicitor, or advocate, serve as a legal officer, or taken up a designated post in the relevant government departments, and the third is to be a special magistrate.
A 同埋 B 嘅
However, under the existing laws, only the experience in A and B can be combined for the purpose of the 5-year requirement, but not C. Therefore, we propose to amend the law to allow C to be so combined for the purpose of the 5-year requirement. Part 5 is related to the operation of the Labour Tribunal. We've reviewed the operation of the Labour Tribunal and identify a number of areas for improvement. First, in relation to the clarification of the jurisdiction. Second, to enhance case management powers. Fourth, early disclosure of information. And fourth, align time limit for enforcing awards. In the paper, we've set out the details. Part 6 is related to the administration of suitors' funds. At present, due to various reasons, the litigants may have to pay to the courts, including tribunals, certain suitors' funds to be deposited with the courts or tribunals. And payments have to be paid out of the suitors' funds to those parties who are empowered to receive the payments. At the moment, the Court of Final Appeal, High Court, District Court, Lands Tribunal, Labour Tribunal, and Small Claims Tribunal have such suitors' funds. The operation of these suitors' funds is in accordance with subsidiary legislation. However, for the Labour Tribunal and Lands Tribunal, administrative, or except for the Court of Final Appeal and Lands Tribunal, which adopt administrative measures instead. So we propose to amend the law to include more specifically worded rulemaking powers. After amending the principal ordinance, we'll proceed to amend the rules related to suitors' funds. And then for the Court of Final Appeal and Lands Tribunal, we'll formulate relevant rules. In formulating legislation for these proposals, we've consulted a number of stakeholders, including the Bar Association, the Law Society, and the Labour Advisory Board. The two legal professional bodies are generally in support of our proposals. The other stakeholders also indicated their support. Of course, some organizations have proposed minor and technical comments, which we've accepted and will be reflected in the bill. As for timetable, we would like to, before the end of this year, finalize the version of the bill for introduction into the LegCo for scrutiny. Thank you, Mr. Lee. Question time for members. Mr. Ronnie Tong, Mr. Dennis KWOK, Dr. Chung Lai Wan, Mr. Wong Yok Man, and Mr. Albert Ho, as well as Ms. Emily Lau, would like to speak. So 6 members have raised their hand. I propose 4 minutes each. Mr. Ronnie Tong, Madam Chairman, I speak in opposition to the right of appeal as of right, which is not in accordance with the spirit of the rule of law. To put it in a frank manner, judges don't want to work so much. For meritorious appeals, they should be handled. Logically, if you say you want to accord more time to meritorious cases, is illogical. Madam Chairman, these proposals won't be able to shorten the process. They only suppress the right of appeal. A hearing may be suppressed to 5 minutes, 10 minutes, or even to a written form. By way of judicial proceedings, members of the public have the right to seek justice. Sorry, I have to say that some of our judges are too arrogant. A litigation may last several years. When lawyers handle a case, they may have to spend several years on it. But for a judge, at most, is to spend a couple of days on it. If the judge says that, oh, this case is non-meritorious, I'm not going to hear it, sorry. As a lawyer who has been in the profession for over 40 years, I really cannot accept this. I have been a judge. I understand the pressure on the judges. Frankly speaking, the pressure on judges cannot be compared with that on counselors and lawyers. If the judges say that, oh, I don't want to do so much work, we would like to do away with the right to appeal. Sorry, that should not be done. Our success rate in appeal cases is particularly high throughout the world. That means the number of cases that went in front of the Court of Final Appeal was high. You see, in a recent case, the Court of Final Appeal overrode the judgments of the previous 2 levels of courts. That means some of our judges may not be experienced enough. In other jurisdictions, the success rate of appeals is generally about 20% only. So, members of the public should understand that justice should not just be done, but be seen to be done. So, if this right to appeal is depleted, then justice may not be seen to be done. I understand why judges want to do it. But the line proposed now, is it too arbitrary? If you believe that the present line is too low, you can change the level of the line. But if you say that you should do away with the line completely, I cannot agree. Now, you have to obtain leave from the Court of Final Appeal in order to appeal up to the CFA. If judges don't even want to do that, Chairman, I really can't agree with them. So, Madam Chairman, I completely disagree with the proposal here. I think you have to view this from the angle of justice for members of the public. Next, Mr. Dennis KWOK. Thank you, Madam Chairman. First of all, I'd like the administration to give us some statistics for reference. For example, in the past 5 years, how many persons have applied for leave to appeal to the Court of Final Appeal? That is, how many leave applications have there been? How many of those have been vetoed? How many in writing? How many vetoed after a hearing? I would like to have the figures both for civil cases and criminal cases. If we don't have these objective statistics, just by reading the wording in the bill, it will be rather superficial to get the bill passed. As Mr. Ronnie Tong said, in actual fact, how many people actually got leave to go to the CFA and how many people eventually won their case in front of the CFA. So before we make up our minds, we must have some data from the administration. As for how other jurisdictions handle such leave applications, their statutory provisions are clearer. When a judge decides whether or not to give leave, the factors to be considered are more clearly spelled out. In our statutory laws, very often the factors to be considered are vague. So should we not look at other jurisdictions as well? For example, Australia. Should we not write those factors in clearer terms, such that if a person fails to obtain leave to go to the CFA, he knows why? This is also very important to the rule of law. Administration, Mr. Lee, any response? Thank you, Chairman. I've heard the honourable members. In the paper, right from the very beginning, we say that one of the major objectives of this bill is that our appeal system should not be pegged to a certain amount of money. So in principle, the present system is not correct, is not appropriate. So this amendment, this bill is to put civil cases on a par with criminal cases. It depends on the merits of your case, whether or not you can go to the CFA. We should not just look at the amount involved, say $1 million. As for the data requested by Mr. Dennis KWOK, we can go back and check them. I understand that you need time to gather those data. Without those data, it's difficult for us to objectively tell what should we do. As the former Chief Justice said, CFA resources have been wasted. However, how many applications were there? How many were rejected? How many were approved? How many received a hearing? Without these data, we cannot just, on the basis of resources, scrutinize the bill. Mr. Lee, I've written down the same issues. You can provide us with the data after the meeting. There will be another opportunity for us to follow up on that. Next, Dr. Chung Lai Wan. Thank you, Madam Chairman. I'd like to ask this question. Whatever law we're discussing, whenever you formulate a law, you of course consider it necessary to do so. Do you have any record on how this $1 million threshold was set? Was it that you're afraid that a lot of people would come forward to apply for leave for appeal all the way up to the CFA just because of emotions? Was it the reason for you to set $1 million as the threshold so as to avoid non-meritorious appeals or unmeritorious appeals? You say that an appeal to the CFA as of right may result in wastage of resources. I think you are contradicting yourself. So my first question is, at the beginning, why did you set that threshold? Secondly, I support Mr. Dennis KWOK in his requests for data. In the past 5 years, how many applications have come in? I mean, how many cases exceeding the threshold of $1 million have actually come in? So, just 2 questions for the time being.
The system started before 1997. At that time, the appeal was to the Judicial Committee of the Privy Council. That was the Court of Appeal for Hong Kong before 1997. This, as of right, appeal is applicable to Hong Kong and also the Commonwealth jurisdiction or Commonwealth jurisdictions. At that time, the amount was $500,000. In 1995, with the introduction of the Court of Final Appeal bill, we reserved this as of right appeal arrangement, and we raised the amount to $1 million. Our proposal is that we want to take away this improper reason. With the as of right arrangement, the appeal system will not be effective, and some cases which are not meritorious will have to be dealt with. And because of dealing the unmeritorious cases, some court time is wasted. Ms. Chen, now you drew a line at $1 million. Would you consider is it the case that as far as it is $1 million, you have to hear that case? Yes, according to law, it is. This is as of right. Yes, we have asked for a paper. How many such cases are as of right, and how many are as of right cases are regarded frivolous? Give us the data. Mr. Wong Yok-man. Thank you, Chairman. Concerning this bill, there are different parts. Because of time constraint, I'll choose 2 parts and I'll give my comments. First, on the oral the judgment to be handed down orally, so that the requirement of judgment to be handed down orally will be scrapped. Now that will save money. It will waste time. It will save time. I was a victim. I was waiting for judgment, and when on the day of judgment, I went to the court. All the lawyers had to be present, and I had to pay the lawyers. That is really meaningless for the lawyers to be present. The judge is just reading out his judgment, and we are just here listening. And that's all of it. Yes, for the reasons for judgment, it will be handed down in writing only. If the judge chooses to do so, that is welcome. But the lawyers may not agree because they earn less. But sometimes lawyers also put everything in one bill, and that may be different. I've checked the court, the High Court, the rules of the High Court, and there is no requirement in respect of handing down a judgment in writing. Shouldn't every level of courts be standardized in this respect? And according to Annex E, concerning the Section 80, Bracket 2, the grounds for or reasons for the verdict and the sentence the delivery of copy of reason to each of the parties, lodge a copy of the reasons in the High Court, so on and so forth. But you do not spell out as to under what circumstances it can be handed down in writing. It may be upon the request of the parties. The verdict has to be delivered orally. So under what circumstances will the verdict and sentence be delivered orally, and under what circumstances that can be done in writing? I think you have to spell it out clearly instead of just leaving it to the judge. And the second question is on calculation of qualifying experience for appointment as magistrates. I do not oppose it. It is a matter of fairness. If one has been a solicitor for 3 years and then be a special judge for special mag for 2 years, and then his 2 years of experience is not counted, whereas one continues as a barrister or solicitor for 5 years is recognized. That is that's unreasonable. We need to standardize accounting. But capability should not just be measured by years of experience, and that is something I want to stress. Concerning professional qualifications, according to 5AB, now the professional requirement of the special magistrate counts the experience as barrister, solicitor, advocate, and they also have different. The calculation is different. So will you consider merging them together? Merging them, the calculation together, Mr. Lee. Concerning giving the reasons of writing, giving the reasons in writing, and that is that depends on the discretion of the judge. One factor of consideration is whether how much time is required to give the reason orally, and also the complexity of the case, and whether there are legal representatives for the parties concerned, and also the language capability of various parties. We will not put it down everything in a straitjacket. We leave it to the decision or discretion of the district judge. As for the arrangement in other levels of the court, for high-level criminal courts, the arrangement is similar. Say in the High Court, Court of First Instance, the reasons for sentence can be delivered orally. In fact, many members are in the line, and several want to have a second chance. So I'll limit the questions and answers to 4 minutes each. Mr. Leung Kwok Hong, Mr. Albert Ho, I have views on several amendments, so 4 minutes will not be adequate. That's okay. I will ask the administration to answer your questions as much as possible. Please ask your questions. At present, the line is drawn at $1 million. If the amount of claim is more than 1 million, then the appeal is as of right. In comparison with the cases in which the claims have to be calculated, the claims that have to be calculated do not have the right of appeal as of right. This, in fact, is an anomaly. Say if there's a debt which is very clear, which is clearly 1 million, even if it is not meritorious, I can still make an appeal. But they say China Chem case, which involved $80 billion, there was no appeal as of right. I find that unreasonable. The present way of drawing the line is not appropriate. Even if you increase the threshold, that threshold amount, that is still not meaningful. Even if leave is required of every case, I have no very strong view. I want the information asked for by Mr. Kwok. Now, the CFA has a committee which requires a written submission, and there is no hearing. There is only trial on paper. That's just like something in the mainland. In the past, Hong Kong did have a hearing. I want to present my case to the judge, and I want to answer his questions. But this right to be heard is not available. And I want the answer in writing. And now, if a leave is not approved, no reason is given. Say you get a Queen's Counsel from the UK, and then they just say there is no merit. If you say there is no merit and don't give reason, then you really unreasonable. I even took that up with Andrew Lee. But he said that was the practice in UK as well. Now, if you heard a case, or if you say in the lower level of the court, you have to give the reason. But if the CFA doesn't give reason, that's really unreasonable. You need to improve upon that. Otherwise, it's unreasonable. You just raise 1 million to 2 million, it's meaningless. That's the first point. And I want a written answer. As for Meg's appointment as permanent magistrate, some of them are not lawyers. The qualification, concerning the qualification, some of them are not legal practitioners. They are not lawyers. Now, let me turn to the labor tribunal. There was no rule, say, for the say in a case in which the employer died, and then it depends on the judge of the tribunal to set the rules. Now, concerning the mandatory sale of property, the court only allows auction but not tender. The legal profession is willing to write in to give the court an additional discretion to allow auction under the mandatory sale ordinance. If you don't do it, I'll do it by a private member's bill. A lot of questions, and he wants a written answer. I believe you need some time, and the panel will follow the matter up. Ms. Emily Lau. Madam Chairman, the amendments cover many policy areas, and some of them are outside our jurisdiction, say, for example, labor issues or the labor tribunal. If the consultation is not thorough, when the bill is before us, there will be a big row. I think the time given today is not adequate. Let me ask this most controversial item. They say they want to save money. How much can they save? Can they give us the numbers? Paragraph 9 is said that other places, other jurisdictions do not have our arrangement, and therefore we need to fall in line with other jurisdictions. So are we unique? Are we the only court which has this threshold? You ask the two legal practitioners associations, and they support you. But the lawyers today the lawyers present today seem not to support you. Well, we've informed other members of the council, but only one non-member of the panel has come. You have to remind them. If there is no thorough consultation when they put the bill before us, they will raise a lot of complaints. Ms. Lee, on the first question, we don't just do it simply for saving resources. At the start, we say in terms of principle, it's really not proper. It's not, say, if the amount is more than 1 million, you have the appeal as of right. But that is unfair to those in which the amount is less than 1 million.
200萬、300萬，因為無論你點樣去做咧，你都係離唔開呢個原則上係嘅問題咯。咁至於諮詢方面咧，咁我哋其實一貫嘅做法，司法機構一貫做法咧，就係話會向兩個律師，即係一個大律師公會同埋律師會咧發文件啦，亦都俾足夠嘅時間去自己內部要有一啲嘅審議，然後去俾翻一個嘅意見我哋。咁我哋收翻嚟嘅意見咧，都係兩個專業團體咧都係支持我哋呢一個即係取消喺民事事項中向終審法院上訴呢一個當然權利嘅。多謝主席。
係劉興議員，
其他地方嗰度咧，係咪真係我哋係唯一全世界仲係得一個地方做
？Well, is Hong Kong the only jurisdiction that is adopting the same system? Will we, in Annex A, compiled statistics on other common law jurisdictions when compared with Australia, the UK, Canada, etc. were not the same as they. In Australia, the UK and Canada, if you want to appeal, in most circumstances, they have a leave system. Ms. Emily Lau, that means throughout the whole world, we cannot find another jurisdiction that's similar to Hong Kong. Mr. Lee, some jurisdictions are more special. In Singapore, they have a mechanism that is different from ours. They don't have a court of appeal to handle appeal applications in the middle. So they have a special mechanism. Apart from Singapore, Ireland is the same. Ms. Emily Lau raised a point that involves labor relations and mandatory sales or mandatory auctions. Maybe you have to consult the two legal professional bodies as well. We still have some time. Mr. Paul Day. Thank you, Madam Chairman. First of all, I have to declare interest. This appeal mechanism to a certain extent, will have a certain relation to legal professionals, so there may be interest involved. I'm concerned about leave applications to the CFA. Just now, colleagues asked for figures. Mr. Ronnie Tong asked for ratios. So how many cases failed to go to the CFA, even after lodging a leave application? As for those cases seeking an appeal at a certain monetary threshold, that is $1 million, how many such applications were there? How many succeeded? And then Dr. Chung Lai Wan, if I remember correctly, in the Constitutional Reform Act 2005, the UK made a decision on appeals. Appeals to the Privy Council could still be allowed. In most of those cases, they're related to African countries. Of course, the UK has already abolished the as of right principle. For Hong Kong, we copied from the UK system by setting the threshold of $500,000 for the district court. I think it's worthwhile for us to take reference from Singapore. A few years ago, we had a CFA case which handed down the judgment that Hong Kong should have a two-tier appeal system rather than a three-tier system as we now have. In this proposal, the administration is suggesting that we should abolish, the 3 bites of a cherry should be abolished in order to save litigation costs. Is it like what Mr. Ronnie Tong said, the judiciary would like to do less work? Or these proposals have certain basis in terms of principles? Anyway, we should take this opportunity to review the whole system. Mr. Ronnie Tong did say that we had quite many successful cases for going to the CFA. For the initial trial and the trial in front of the Court of Appeal, usually will have the same judgment. But when it goes to the Court of Final Appeal, very often the outcome may be different. Is it like what Mr. Ronnie Tong said? Our judges are not competent and experienced enough, such that it's necessary for cases to go to the CFA. In the CFA, we have some foreign judges with new ideas and thoughts, and their standard may be different. Mr. Lee, what about appeal as of right? Mr. Jay asked about the Privy Council leave. In this exercise, we've not yet looked into that. In the UK, they've already abolished the as of right mechanism. What about the Privy Council? Allow me to go back and collect some information after the meeting. I'd like to remind members to avoid using cocktail language. Secondly, the as of right mechanism is very important, so we all want to know the details. Next, Mr. KWOK. Thank you, Madam Chairman. Paragraph 15 of the paper says that in order to allay, or instead of paragraph 15, it should be paragraph 50. There it is said that if a party concerned would like to seek assistance from a trade union, can the trade union read the relevant documents? Well, if a trade union observes unfairness and injustice and make a disclosure, will the trade union be considered a receiving party? And then in paragraph 64 of the paper, it is said that apart from the Bar Association and the Law Society, the other stakeholders, though in general support the bill, have raised minor and technical comments. What do you mean by minor and technical comments? Should members be informed of these minor and technical comments? Mr. Lee, perhaps I should first answer the question on paragraph 50. We, of course, would like to encourage both parties to disclose the relevant information as early as possible. If there is early disclosure, then both parties to the litigation will be able to understand where the controversy lies. If one of the parties is worried that after disclosure the information and document may be abused and therefore is unwilling to disclose them, then we would like to make it a statutory duty to the effect that unless the court or the tribunal has set other criteria, if the information and document are already disclosed in the hearing, well, he's not answering my question. Would he please answer my questions directly? Mr. Lee? The tribunal and court have statutory proceedings to follow. So if those proceedings are observed, then the rights of both parties can be protected. Mr. KWOK asked about trade unions. That is, whether trade unions will be affected by tribunal proceedings. So the answer is not that clear-cut. You have to consider a number of factors. I think trade unions are very concerned. They would like to know whether they can have access to documents and information. So they would like to have a straightforward answer from you. If the present requirements are not clear enough, can you further clarify them so that trade unions will have the right to read documents and information? We can go back and follow up on that. What about my second question? Opposing views. Are there opposing views that are worthy of our reference? Well, those minor and technical comments are mainly related to the drafting aspect. Some comments are related to the Labor Tribunal. For example, there's this question of whether or not legal representation should be allowed in front of the Labor Tribunal. We'll go back and explain to the Labor Tribunal. Well, perhaps our discussion will not be confined to technicalities. So I think in future we'll have to discuss the rather important changes. Mr. Leung Kwok-hong? Madam Chairman, for deputy judges, I absolutely object to the proposal that a person with no legal qualification can serve as a deputy judge. A non-lawyer should not serve even as a prosecutor, not to speak of a judge, a deputy judge. I'm not trying to protect the privilege of lawyers. If a non-lawyer person is made a deputy judge, the system will undermine the interests of the litigants. As for the operation of the Labour Tribunal, a reform is necessary. I think you can disclose certain documents and information to trade unions. I think the direction of reform is very clear. If a worker or an employee receives certain documents and information, why can't he pass them to a trade union? How is it different from passing those information and documents to a lawyer? Trade unions, of course, work for the interest of workers. If a worker is not to employ a lawyer, why can't a trade union have access to these information and documents? You have to respect the right of trade unions. Otherwise, trade unions will be useless. And then for this threshold of $1 million, which give the litigant the right of appeal as of right, that's not correct. Such a stipulation is outdated. You should just drop it. The remaining question is what reform is necessary. And then there's this question of judgments. The district court cannot use direct written judgments. It's better to have flexibility, but I would like to lodge a complaint. Very often we're unable to obtain sentencing from a judge for a long time. That person is already in prison, and you tell me that you have not completed the writing of the judgment. A review is necessary. The person is in prison. If the reasons are very simple, do it quickly. If the reasons are very complicated and you don't really how to tidy them, then don't sentence a person to imprisonment. If you're not competent enough, find somebody to help you. Masters are employed to assist judges. You try to stay in prison for a few days to wait for a judgment. Lawyers try to obtain judgments as soon as possible. They want to lodge an appeal, but then the sentencing is still not handed down yet. So that situation is absolutely intolerable. Trade unions' access to documents and information. Mr. Lee, we'll go back and consider that. Concerning the deputy judges, this bill does not have any proposal on them. As for the as of right principle, I've heard Mr. Leung Kwok-hong. We now propose to abolish the as of right mechanism. As for complaints, we've heard you. What about trade unions?
Now, can you give them, can you exempt them? Can you give them exemptions? Or give them immunity? Yes, we will list the questions for the administration. Mr. Martin Liu and then Mr. Martin Liu and Mr. Tan Ka-pyo, and then 2 members will have a second round, and I'll draw a line there. Mr. Martin Liu. Mr. Martin Liu. Thank you, Madam Chairman. With regard to taking away the as a right appeal, I have strong reasons for that. But whether you have considered, I wonder whether you have considered the consequence. If we take away the as of right appeal, then people who used to enjoy the right will have to go to the court to appeal for leave from the Court of Appeal, and then he will also have to go to the CFA if the leave is not given by the Court of Appeal. The application is costly. How is the administration going to deal with that? Will it not lead to substantial increase in legal costs? Mr. Lee, without the as of right in respect of making an appeal, and then any appellant will have to take that into account. He has to take costs into account. If you keep that as of right arrangement, then he will have the incentive to appeal.
如果廖議員冇跟進，
If Mr. Liu doesn't have any, yes, Mr. Liu, do you have any follow-up question? No, I'll follow that up later. Mr. Tan Ka-pyo, I want to follow up the question asked by Mr. KWOK. Have you ever consulted the LAB on paragraphs 49 and 50, and have they commented on that? It seems that the arrangement is to allow the cases to be dealt with speedily. It looks good apparently, but if you attach a liability of contempt of court to that, you better do away with that. Usually, it is the employers who hide the contracts, who hide the attendance cards, and if the union produces these documents, then the unions will be sued for contempt of court, and that's a problem. The FTU, according to the experience of the FTU, things have changed. In the past, when you present an evidence that the member is, that the claimant is a member of the union can speak on behalf of the claimant. But now it is up to the decision of the judge, and it really depends on the mood of the judge on that day. Do you have clear guidelines to allow the unions to be a party for receiving the documents, and also a party that can represent the labor workers? Concerning paragraphs 49 and 50, we did consult the LAB, but they didn't give any specific special comments. As for the role of the trade union, I say that I need some time to study that. How much time do you need? Will you take out 49 paragraphs, the proposals under paragraphs 49-90? Well, at the present stage, we have no such intention. We have different views. We need to think on this before we decide on the step forward. I hope you will go to the court to see if there is any guidelines concerning the role of the trade unions. We've heard that. I will talk to the court. 2 members will have their second round. Each will be given 2 minutes. Mr. Dennis KWOK and Ms. Ann Cheng. Mr. Dennis KWOK. The Bureau has not answered my second question. Assuming that we do away with the 1 million threshold, or we do away with the as of right appeal, will you be more specific in setting out the factors for the courts to grant leave? Now, you want to align the rights of appeal between civil and criminal civil and criminal cases. But that is the provision of substantial grave injustice in respect of criminal appeals. So concerning the factors of consideration for discretion, I hope that you will spell out the factors more clearly, so that when people have their leave application rejected, they know exactly what the reasons are. Yes, we'll carefully consider members' views. Ms. Ann Cheng. Madam Chairman, I want to speak on the handing down of judgment in writing without the need for oral presentation. Now, say the judgment day is day X, and then after a period of time is Y, day Y, and then you really don't know when you get the written reasons. The time gap is very long. Now, if the sentencing, now when the person is still waiting for judgment, the person is still assumed to be has the presumption of innocence, but the person may still be held in custody, say for another month, because he is waiting for the judgment. First of all, there must be a judgment first, and then followed by a sentence. The present arrangement is that both has to be done orally. Our proposal is that a judge can give the reasons for judgment in writing. As said in the appendix, or in the annex, both parties will be given time to study the written written reasons. Yes, I want to follow. My question is, there is judgment, there is written reasons, then there's sentencing. How much is the gap between judgment and sentencing and the handing down of the written reasons? Well, in fact, there is no time limit. Madam Chairman, now in giving the written sentence, will that take a very long time? You know, somebody is in custody, as mentioned by the member. Yes, we will follow that up. I have several questions concerning the as of right of $1 million, apart from unifying the standard between criminal and civil appeals. I think if there, you want to, one of the reasons is that you want to save resources. Now, when you take away the as of right, it is a very serious matter. Can we just instantly agree to cancelling that as of right? Apart from asking for the numbers, I would like to ask the following. Not just the chance of the number of winning or losing. Now, we also need to know whether the case is arguable or not. You need to consider the number of arguable cases and cases that are frivolous. Whether it's 1 million or not, some may just want to seek justice. And because people, I've handled a case in which the party concerned has not given it up for 38 years. It's not just a criminal case. It's also about civil justice. People wants to seek justice. The right to contest or the right to make an appeal should be handled carefully. I know that there are resources and issues, resource-related issues, and judges have heavy workload. If judges but the court doesn't have enough resources, tell us, and we will provide resources. And the LegCo is willing to assist. As for opposing voices, you just say that you have considered them. You ask that is a question on whether there should be legal representation at the tribunal level. It's a very important issue. Concerning those things, you think that minor, the oppositions, the objections are minor or technical. What are they? Can you give us a paper on that? I think the questions asked by Mr. Ho, he asked those questions to be answered in writing. I think you have to do so, and I don't repeat them. As for the union's right to have access to the documents, I hope you can consider the following direction. The unions should be allowed, to have access to the documents if they are authorized by the workers.
They shoulder the same responsibilities as we. So trade unions are helping the workers. They should have access to documents. If certain documents cannot be disclosed immediately, trade unions can give a guarantee and then be allowed to read them. And then you should publish clearer guidelines on access to documents by trade unions. The trade unions are helping workers. You must not ask the workers concerned to go through a lawyer or a legal professional body before they can have access to documents and information. So you have to provide us with answers to all these questions. There are voices in support of some of your amendments. Mr. Ronnie Tong, I would like to say this. The administration is, in a very rough manner, putting forth 7 to 8 proposals in one go, in the hope that we can give our approval very speedily. The administration should not treat this discussion in this panel as a pre-approval for the bill. Madam Chairman, can we call another meeting to study this bill? Yes, we can consider that possibility. Mr. To? Chairman, I agree that if a worker has no legal representatives, the trade union concerned should have access to documents and information. But then, Madam Chairman, you should not compare that situation with the situation in which LegCo members can allow their assistants to read confidential documents just by signing a guarantee. I do not agree that confidential documents should be handled to our assistants just by asking them to sign a confidentiality guarantee. Well, that happened in the Lehman Brothers incident. We don't need to bundle this discussion with that. We can handle that issue separately. Dr. Chang Lai-wan, no. I think this panel has to give some indication on its preferences. So do we agree that the administration introduce the bill to the LegCo? Of course, they're not asking us for approval for the detailed proposals. They just want to know whether they should introduce these proposals to the LegCo by way of a bill. Mr. Ronnie Tong, Madam Chairman, we should have another meeting. Ms. Emily Lau, Madam Chairman, we haven't finished with our discussion yet. I think we have to clear up all these ambiguities and disputes first. Maybe they should go to the manpower panel as well. So, Chairman, you should call another meeting and invite other members to attend as well. Mr. Dennis KWOK, well, I think our opinion is very clear. We've asked many questions. It is difficult for this meeting to agree to your introduction of the bill to the LegCo. Because if we give that approval, you will introduce a lot of policy details at the same time. So, this meeting has not given you consent to introduce the bill to the LegCo. After you've given us answers to our questions, information requested, etc., we'll call another meeting to handle this bill. So, if it is agreeable, we'll call another meeting. Dr. Chang Lai-wan, are they going to proceed with a whole basket of proposals? Well, some of our colleagues deem some of the proposals problematic. Well, Dr. Chang Lai-wan, we've discussed a lot of problems just now. It is difficult for us to select which proposals should be given our approval. I think we should allow Mr. Lee more time to go back and follow up on all these issues and questions. Well, I think we still have time. We can wait for a few more months. We can come back in October. We can give members more time to deliberate on these proposals. Then we don't need to make a selective decision now. All right. That's it, Mr. Lee. Let's proceed to the next item on the agenda. Mechanism for handling complaints against judicial conduct. Is paper 871-02. This is a paper on the mechanism for handling complaints against judicial conduct. There's another paper that is 670-01, submitted on the 22nd of May this year by Mr. Wong Yong-man and Mr. Leung Kwok-hung. In that letter, they ask for a discussion on masters. In fact, at a previous meeting, we also discussed the issue of masters. Members agreed that we should have a discussion today. I'd like to invite the Deputy Judiciary Administrator, Mr. Esmond Lee, to brief us on the paper first. Thank you, Madam Chairman. The paper briefs members on the mechanism for handling complaints against judicial conduct. The judiciary attaches a great deal of importance to the conduct of judges. Anybody complaining against a judge, so long as reasons can be given, will be dealt with in a fair and proper manner. Actually, it involves the independence of each judge to adjudicate according to law, without any interference. Judges have the duty to resolve disputes. Anybody who disagrees to a judge's decision can seek an appeal under the existing mechanism. Now, this paper targets the mechanism for handling complaints against judicial conduct. I think we have to respect judicial independence. At the same time, complaints against judges should be dealt with in a fair and proper manner. In the paper, we have included a table to show that all complaints against judges are handled by the Chief Justice and or the court leader of the relevant level of court. In paragraph 8 of the paper, we say that all complaints will be forwarded to the court leaders immediately, such that they can investigate into the matter concerned. After investigation, the complainant will receive a written reply. The court leader concerned may take further action as appropriate, for example, by reporting the matter to the Chief Justice, or where and when appropriate, inform the Judicial Officer's Recommendation Commission. As regards the time frame, it depends on the nature of the complaint, the complexity of the matter, as well as the circumstances surrounding the case concerned. Thank you, Mr. Lee, for your introduction. The floor is now open to members. 4 members have raised their hands. Oh, Mr. Leung Kwok Hong also. So 5 members altogether. 5 minutes per member. First of all, Mr. Tam Yu Chong. Madam Chairman, I very much respect the judiciary and judges, but respect is respect. If there is a complaint against a judge, the paper now introduces the mechanism for handling such complaints to us. But the paper is rather simple. Allow me to ask some specific questions. For example, paragraph 8 of the paper says that all complaints will be forwarded to the court leaders for investigation. By the word all here, what do they mean? Do they mean each and every complaint? Is it that the court leader will initially read all the details of the complaint concerned? You see, sometimes a complaint can be frivolous. It may not actually target the misconduct of a judge. So what about the vetting procedures? Can we have the details? Mr. Lee? Thank you, Madam Chairman. Thank you, Mr. Tam, for your question. Yes, in the paper, the word all means all. Because we're talking about complaints against the conduct of judges. So the Chief Justice or the court leader of the relevant level of court should handle such complaints. There won't be any preliminary screening to see whether or not a complaint is substantiated. Paragraph 6 of the paper says that different levels of the court have different court leaders, such that we can effectively handle complaints received. Can I ask a follow-up question? If a complaint against the misconduct of a judge is substantiated, paragraph 9 of the paper says that advice would be given to the judge concerned. Is that a kind of punishment or disciplinary action? That means if the complaint is substantiated, the judge concerned will be advised. Is that the only punishment? Is there any other form of punishment? Well, this is a disciplinary system. Under the Basic Law, procedures and disciplinary actions against judges vary. For judges, according to Article 89 and 90 of the Basic Law, district court judges or above can, in accordance with the Chief Justice of the Court of Final Appeal, form a 3-person panel to study the matter and dismiss the judge only when the judge is unable to discharge his duties. Articles 91 of the Basic Law and Cap 483 of the Laws of Hong Kong mention that there should be an independent tribunal to conduct investigation, and that is another mechanism to handle judicial officers. To reply to Mr. Tam Yu Chung's question, it's not just as simple as an advice. It depends on which level of court the judicial officer concerned is. Well, I think your paper should carry more details, and then we don't need to ask so many supplementary questions. You just mentioned advice in paragraph 9. I think the paper is too simple. All right, the paper should carry more details. Next, Mr. Albert Ho. Madam Chairman, in the past 30-odd years, I had encountered a number of cases in which complaints were lodged against judges. I myself had lodged such complaints as well, and other lawyers had done so also. The competence of a judge may not necessarily be related to the judgment of the judge, because if it is a wrongful judgment, the person aggrieved can lodge an appeal. But we're not talking about wrongful judgment. We're talking about misconduct on the part of judges, which cannot be resolved by appeals. I understand that by and large we should rely on the self-discipline of judges. Under the Basic Law, there is this mechanism to dismiss a judge. But very often, the cases are not as serious as that. For example, in a case, a judge was reading a novel during a hearing, and somebody observed that, and eventually that judge resigned. And then there's this deputy judge who was engaged in mobile phone conversations. And then he was no longer a deputy judge. Sometimes abusive language might have been used by the judge, but of course that doesn't mean that his judgment was wrong. The judgment was correct. I inquired about such cases, and no specific answers were given to me. There was this judge who resorted to unreasonable reasons in granting bail. For example, he required that person to report to the police station at unreasonable intervals. As far as I can remember, that case happened 20 years ago. You cannot dig out the file anymore. So I complained, and then the judge was transferred to the library to do research.
I think there is lack of transparency. The complainant just doesn't know whether they have done anything. Of course, the lawyers know. How many complaints are there? Do you have the statistics? How such cases are handled? Have you explained it to the complainant or reply to the complainant? If a mistake is made, there should be an apology. But it seems that judges don't want to make apologies. But if you make a mistake and you don't need to apologize, I just ask whether I asked Mr. Ronnie Tong whether he has seen a judge apologize. I've never seen a judge apologizes. He may smile to you, maybe. I'm not complaining, but I think they really need to give a full account of that. There is an annual report by the judiciary, and we have complaint figures in 2012 with regard to complaints against judicial decision, 74 cases. Against the conduct of judges, 31 cases. Complaint against judges and also judgment, 21 altogether, 126. In comparison with the cases handled by judicial officers, 522,000 cases. So if you compare that with the complaints against judges, that is only a very small proportion. As the complaint against the behavior of judges, in 2012, one case substantiated, partially substantiated one. As said by Mr. Ho, after handling a case, the court leader has to give a written reply to the complainant. And there were examples in which an apology is made to the complainant. Yeah, there was? Was there? Yes, there was. Was there an apology by the judge? That was not in number. And we had records. The behavior of certain, because of the behavior of certain judicial officers, the court leader gave an apology. Ms. Albert Ho, you don't further questions? Mr. Ronnie Tong, judges in discharging their duties have to do it without fear. And but we don't have a transparent system to deal with complaints. When I was the chairman of the Bar Association, I received complaints from barristers, and I wrote on his behalf to the chief judge. Generally, they gave us a reply. He considered the matter. He looked into the matter. They would carefully handle the matter. I have never received any apology from a judge. The system is really undesirable. It seems that the government is just saying that if you are not happy with the judgment, you can appeal. We are not talking about this. We are talking about inappropriate behavior of the judge who is hearing the case. And that has cast doubts in people's mind as to the impartiality of the hearing. That is a very serious matter in respect of the rule of law. If there is no transparent mechanism to deal with that, then you just have not dealt with that. The case you mentioned, nobody knew. Nobody knows. Even if you have replied to the complainant, that's not adequate. Because this is about the judicial system, the impartiality of judicial system. You cannot do it according to the foot. You need to have a regular and transparent complaint mechanism. We don't ask for penalizing the judges. We need to let the public know that if there is any inappropriate behavior by the judge, there is some way to deal with that. We don't ask for deducting his salary or beating him 30 times. We just want a transparent system, and we hope the administration will consider that. Mr. Lee. The present system is an open system which let the public know. If you have a complaint against a judge with regard to his behavior, we deal with that. And the relevant court leader looks into the case, and if need be, the record of the court will be listened into, and then the judge is required to give an explanation. Upon completion of the investigation, the court leader will reply to the complainant. There is a mechanism. As for disclosing the statistics, we will consider doing that. In the annual report of the judiciary, we do have numbers disclosed. Whether more can be disclosed, we can go back and consider that. I think my complaint is that the transparency is not adequate. You should consider how to enhance transparency so that members of the public know there is a mechanism handling this problem. They ask for a more transparent mechanism. Let people know the operation of your system and be accountable. Mr. Dennis KWOK. I don't have 40 years of experience as Mr. Ronnie Tong. But I can see that in the lower level courts, say for example at the magistracy or at the lands tribunal, the behavior of certain judges is really awful, and they are not suitable to be judges. Now there are many junior lawyers who go to these courts, and they've made a lot of complaints, and they're really saddened. You mentioned 126 complaints in 2012. How many are at the magistracy level? I don't have the numbers. Please go back and find it out. What level of court, what level of judges have been the subject of complaint? Of the 126 cases, how many have been followed up? The court leader, I don't like the name, court leader. This is a this is a senior judge. Does he just listen to the tape and just give that complainee a pat at the back, on the back, and then what does that senior judge do, or the court leader do? I think training is very important. If you just appoint a person to be a magistrate or a district judge or a high court judge, then he knows how to be a judge. Apart from legal knowledge, legal wisdom, the person's attitude is also very important. He must have good attitudes, and he must be very balanced. And some high court judges, some senior judges have told me that there is not enough training for judges, and even new judges don't know how to be judges. Their attitude is not right. Being a judge doesn't mean that you need to be aggressive. You need to let people see that you are fair. You need to be seen to be fair, seen to be just. The experience of the litigants have the feeling that justice is not done. So you need to provide adequate training to judges. Ms. Lee. We'll try to find out the numbers. As for training, that's important. That's a priority of the judiciary. we provide appropriate training to judges and judicial officers. Will they give us the numbers? We ask for the numbers. We try to find the numbers. You don't need to try. There must be such data. We have to find out whether the classification. I mentioned 126 cases. That's based on the annual report. In collecting the data, they are not collected. They may not be collected as what is required by Mr. KWOK. We ask for those numbers. Mr. Leung Kwok Hong. Mr. Leung Kwok Hong has issued a paper to members, and this paper is issued to members out of his own initiative. He may have to poke the paper, but this is a paper issued by Mr. Leung Kwok Hong. Well, I take the responsibility. I have immunity. The first thing I want to say is this. Now, they complain against misbehaving judges and the complaint against integrity of the judges. The system is not transparent. The misconduct of judicial officers which leads to, say, complaints or reprimands or punishments have not, and nobody knows that. 156 cases. Are they cases that have been substantiated? I really don't believe that the number is so small. There is nothing new. Say in California, in the U.S., there is such the arrangement. There is the Commission on Judicial Qualification. In 1976, there is the Commission on Judicial Performance. Now, from qualification to performance, and then in California, there is a committee of judges. It was set up in 1990. In order to let the rule of law prevail, you need to have the self-discipline of the judges. It is not an appeal against the judgment. The judge may behave very poorly, but his judgment may be good. Evidence is adequate, but the judge just abuse the lawyer of the defendant or abuse the defendant, humiliate the legal representative of the defendant. That's not right. And if you do this, then people will criticize the judge. And where is the solemnity of the judge, of the judicial system? Where is justice? Is justice seen to be done? Now, even if a oral criticism is made by a senior judge on that junior judge, that is only within the court, and it's not widely reported, and people just don't know. You really need to have a scorecard for the judges. Maybe something like that in the kindergartens. Madam Chairman, I asked for a hearing on whether there should be a complaint mechanism to deal with the behavior of judges, and whether the present mechanism is appropriate and should be improved. And also, the fourth power is very careful about criticizing the judges in the court.
In a modern society, we should clarify this matter. That is, what is the check and balance between the fourth right and the other three rights. So, Madam Chairman, I sincerely urge you to call a public hearing such that members of the public who have served as judges, lawyers, litigants, or those who have been aggrieved by judges can air their views and feelings. If there are incompetent judges, then not just the judiciary should act. Lawyers and other members of the public should also act, because the misconduct of judges will be made known to the public, and something should be done on them. Of course, we don't have any more time in this session, but when we come back after the recess, we should call a public hearing so that different sectors of the community can air their views here. All right, time's up for you. Mr. Porter. Thank you, Chairman. I agree that we should understand more the public views. If you're talking about judgments, particularly written judgments, I believe most judges have been very careful because the judgments are all put on record before proceedings. Take, for example, when a suspect is charged, sometimes the courtroom can be very crowded. If a suspect is not legally represented, the attitude of the judge may not be too satisfactory. But then litigants very often dare not complain for fear of retaliation. Lawyers are also very clever. They're also afraid of retaliation because lawyers may meet the same judges again in future. So very often the parties concerned are not willing to lodge complaints. So there must be a standing mechanism which is transparent enough to pose a deterrent effect. The members of the public will know that they're protected. So even judges of courts of first instance will be more careful. The administration's answers just now were very vague and ambiguous, even on figures. That shouldn't be the case. Judges should no longer be considered as in a supreme status. And then we should refer to other jurisdictions to see how they handle complaints against judges. In the paper, we're told that the judges of a higher level will be taking action against judges of lower levels. You see, even in the tourism industry, we are now proposing a tourism industry, a travel industry authority to handle complaints. Well, I often received complaints about travel agencies. In certain cases, even minor incidents were uploaded onto the internet, so the travel agency concerned will be affected. For judges, if there is misconduct on the part of a judge, I think we should have more transparency such that judges will be more careful in their temperament, their attitude, etc., towards the parties concerned in court. Well, I'll make use of the remaining time to give my remarks. No reply is needed. Mr. Leung Kwok-hong mentioned the role of the media. Well, some members of the media may risk being charged with contempt of court in making video or audio recordings, but very few members of the media dare to do so. To a certain extent, I believe we can open up the courtroom to members of the media for videotaping or audio recording. I really don't understand why our court proceedings cannot be simplified to allow for more media participation. Besides, the judiciary should have staff members to observe court proceedings so that judges can be tested for their competency. Professional experience and qualifications also matter, but how they handle people is also very important. In Europe, they have schools for judges. So I don't know whether we have such schools in Hong Kong. So maybe the judiciary can do more by way of more frequent inspection. Next, Dr. Chung Lai-wen. Thank you, Madam Chairman. There must be check and balance for everything. The executive is checked and balanced by the legislature, that is the LegCo, and the LegCo has its constituents to check it. For the judiciary, I can't think of any check and balance. We look at the table about complaints against judges. It said there that all complaints against judges are handled by the Chief Justice and or the court leader. By court leaders only. So there is conflict of interest. And then if a court leader considers it inappropriate for him or her to handle a complaint, as this may lead to any real or perceived conflict of interest, he or she may instruct another judge to handle the complaint. So, it's still internal investigation. No matter how much investigation is done, it's not satisfactory. There must be a certain degree of transparency before the judiciary can be credible. We mentioned qualifications and experience for counselors. What about the magistrates and judges? Understand that many of them graduated from the law school, entered the Department of Justice, say, for just 3 years, and then became a judge. These judges don't understand what society and people are all about. And sometimes a judge may consider only that a person is not honest. Then he passes a judgment on that person. Such judges never understand society and people, but they are passing judgments on members of the public. Is that rather dangerous? Do we have a lot of grievance cases? And then what about these complaints against judges? If the complaints are substantiated, what's the consequence? The consequence is that appropriate advice will be given to the judge concerned. I hope that our judiciary will continue to improve. There must be an appeal mechanism. For the Security Bureau, we have the IPCC. Well, people should not investigate into themselves, otherwise Mr. Justice Ma will have a difficult time. We all know which judge is competent, which judge is not. For the incompetent judges, they should retire as soon as possible. Well, can I ask the administration for this information? How many percentage points of the total number of judges have never served as lawyers? concerning an institution beyond the judiciary to investigate into complaints against the judiciary, I'd like to relate to members the opinion of the Chief Justice who opposes the suggestion which may undermine judicial independence. As for the data requested, I'll go back and see whether we have the data. Chairman, Dr. Chang Lai-wan, I'll give you a second round. I have 5 minutes, Chairman. All right, I'll let you finish. Okay, you're correct, you're correct. Well, Mr. Justice Ma will definitely oppose our suggestion because we are trampling on his ground. But can you talk to him? It's good for him. You see, if all these complaints are to accumulate, if all these grievances are to accumulate, eventually there will be a big blunder. So we are doing this for his good. Can you go back and suggest this to him? Well, let me make an announcement. Now it's 6:30 p.m. I can exercise my discretion to extend the meeting by 15 minutes. Now, Ms. Emily Lau and Mr. Dennis KWOK would still like to speak. Any more? Mr. Leung Kwok Kong, I'll draw a line there. Ms. Emily Lau? Madam Chairman, I believe we have to handle this issue very carefully. The rule of law and judicial independence are our core values. Of course, if there are problems, we should discuss them. I believe Mr. Lee has already heard a lot of views today. He should go back and discuss with the judiciary. And just now we asked for certain figures. Every year, the Chief Justice of the CFA invites us to lunch and have a discussion with him. I believe Mr. Justice Ma, the Chief Justice, will continue to serve in October. So I believe we'll be invited again. We're willing to talk to him. But this matter is our concern, is a social concern. I would like Mr. Lee to give us all the facts and data. I'd also like to hear the response of the Chief Justice and what sort of changes in the existing mechanisms will he consider. But at the same time, we should maintain the dignity of our courts. It's not for the judges, but for Hong Kong. We have to strike a balance. The Chief Justice should know that there are complaints against judges. So, Mr. Lee, no problem for you to come back to this panel. At the same time, I hope that we can have a meeting with the Chief Justice as soon as possible so that he can explain to us how he responds to members' concerns and society's queries. I'll relay the message to him.
Now, the second round. Mr. Dennis KWOK, Mr. Leung Kwok Hong, and Ms. Ann Chang. 2 minutes each. I'll draw a line there. Mr. KWOK. Just now, a member mentioned an appraisal mechanism. Within the judiciary, if judges can do that, that will be very important. You really shouldn't wait when there was a scandal or when people make a complaint. Before that, there can be senior judges that can correct the misconduct of the junior judges. Among the magistrates, how many who have not been lawyers in private practice before they are appointed to be judges? I want to know that as well. I know that many magistrates have been directly appointed to the seat after they have worked in the DFJ for several years. I want to know whether many magistrates have been transferred, quote unquote, from the DOJ to the magistracies, and I have reservation about this arrangement. That's about quality of judges, right? Mr. Lee, you will give us a written reply, please. Mr. Leung Kwok-hong, I think what's said by Mr. Justice Ma is not reasonable. We are not trying to get a superior mechanism to change your judgment. Our concern is that your judges don't comply with the rules, don't comply with the law, or the judges who have poor attitude will make a complaint, and we really don't know whether the complaint is substantiated. Should there be an impartial body to deal with that? The answer should be yes. That's the experience of California. Some retired judges, some representatives of the community look into the complaints. There is a mechanism. The nature of complaints, the details, and then they come to a conclusion. At the start, we are not familiar with that, of course, but this will not undermine the quality of our judiciary. If a government is criticized, the government will become less and less capable of ruling. That's really. I think if the government is open to criticism, the government is more capable. I will not belabor the point. Hong Kong needs to have this mechanism. Our court tries many cases. I hope an arrangement can be made for a hearing. We are not asking for firing the judges. We are not asking for changing the judgment. Under the basic law, there is a mechanism for dismissing judges, but the complaints have to be established first, and the threshold for dismissing a judge is very high. Ms. Ann Chan. Chairman, just now I asked for the information because I'm concerned about the quality of judges. I've heard that judges, in making a decision, they said something which showed that he didn't know the things which everybody in Hong Kong knew. Say, you bought a property in the mainland, who act on your behalf in the mainland as legal representative. The judge said, well, in the mainland, why didn't you need a judge to, why didn't you need a lawyer to do the property conveyancing for you? But in fact, in the mainland, you don't need a lawyer to do conveyancing by a lawyer. And also, there were also very nasty words used by judges to describe the defendant or to describe the parties concerned. Now, Justice Ma is the head of the CFA. We can make suggestions to him. Now, he cannot just say he opposed that and full stop. He must give reasons. Now, we have the ICAC, which investigate government officials. Today, a complaint is made against an official. The complaint is made to the ICAC, and ICAC is look into that. Electrical members are subject to complaints, and there are sanctions. So does the police. Why is the judge free from that? We need to spell it. We need to find an answer. We need to see the reasons. I think Mr. Lee has heard members' voice loud and clear. Now, judges are humans. The paper gives us an impression that the present mechanism is just a rule by personality, and that is not appropriate. We have high hopes towards the judicial system. The rule of law depends very much on the judicial system. We are not the appropriate body to handle complaints against judges. I have thick files of complaints against judges. It's not about complaints against judgment. They just feel aggrieved. If the court just gives people the impression that it's not fair, it's a problem. The judiciary has to seriously consider our view in respect of improving its complaint mechanism. If the court just rejects it offhand, then there will be stronger demand for changing the mechanism. The court or the judiciary has to exercise self-restraint and self-discipline. And if it is self-disciplinary mechanism is not seen, then people will ask for more and more people will ask for intervention. We really need a positive reply from you. Now, apart from the numbers we asked for, I also want to follow up on the following. How many cases have been brought before the Judicial Officers Recommendation Committee? What recommendations have been made? What kind of sanctions have been meted out? I think even complainants may not have known that. There are a lot of grievances. There are a lot of aggrieved cases. You need to face up to that. Article 89 of the Basic Law provides that if a judge misbehaves, there will be certain consequences. What do you mean by a judge involving in misconduct? Mr. Albert Ho mentioned a judge reading fiction while hearing a case. That has been widely known and is taught in every law school. Have you apologized to the complainants on behalf of the judiciary? How many are there? Can you let the public know that you really face up to this issue? It said that there is an independent tribunal. How is that independent tribunal to be triggered? Your present answer is not acceptable to the LegCo. There are very strong demands within the members of the public, and we have received many complaints. I've handled many such cases. Many feel that justice is not done, and their mental states are affected. How many judges have not been practicing lawyers before they are appointed to the bench? Is there any, in other jurisdictions, are there other more transparent mechanisms to deal with misconduct or misbehavior of judges? The mechanism is not to take away the power of the judiciary. It is to help the judiciary to make it more convincing, to make it it also be effective in reducing complaints. You shouldn't wait until it explodes. Society has changed. The judiciary has enhanced its transparency in particular the handling of complaints against judges. Will there be a hearing? I need some time, and I will talk to different members and listen to their views. And then I will explore whether there is such a need. Certainly, there is this need, and that is this panel will follow the matter up. Now, give us the information we asked for. Have you looked into how other jurisdictions deal with complaints against judges? How do they enhance transparency? This will be our outstanding item for discussion as well. I think we can only stop here. There is one more thing concerning the voice recording in the court. Although it cannot be disclosed to the public, can the complainant listen to the recording of the whole proceeding? I've handled such cases. A judge, or rather, the lawyer, is the first one who would think twice before making a complaint, because he may face the same judge again in the future. And the appellant also faces enormous pressure, because that may affect his or her appeal. I think the mechanism is very important, and that will help to enhance the image of the judiciary and whether the judicial system is fair or not. I sincerely urge you to consider having a hearing, a public hearing on that. Yes, I certainly talked to other members. We are not going to have a next meeting very soon. We will have another meeting to follow up the complaint mechanism against judges. We have nothing against a particular judge or a particular person. It's about the mechanism. In respect of improving upon the mechanism, there is a need to maintain the standing of the judiciary in the eyes of the public. Thank you very much. May I wish you a happy summer vacation.